Hello, my name's Sarah Garvey. I'm PSL Counsel in the Litigation Department at the international law firm Allen & Overy. Today I'm going to be speaking about Applicable Law Regulation 593/2008 on the law applicable to contractual obligations, otherwise known as Rome 1. So by way of preliminary, I'm first going to talk about some terminology which is helpful to clarify at the outset. Before bringing any claim, including a counterclaim, you need to consider two preliminary matters. First of all, whether the court has jurisdiction to hear the claim, and secondly, which law it will apply to resolve that dispute. Now, these are separate but closely related issues. Different courts will apply different rules to determine governing law, so you need to consider your jurisdiction first. You need to consider which courts will resolve the dispute. Secondly, courts can apply foreign law to determine disputes before them. And today we're going to talk about the approach of the English courts and other member state courts to determine the contractual governing law. Now on this slide, I've just set out an overview of the governing law regimes applied by the English courts to determine the governing law of contracts. So that's Rome 1, the Rome Convention, referred to in the slides as RC, and thirdly, it may apply the common law or statute or another international instrument in certain circumstances. But we're going to focus today on Rome 1. I'm going to start to outline the scope of each regime. First of all, Rome 1. This is applied by the courts of all member states except Denmark to contracts entered into on or after the 17th of December 2009. It applies to all civil and commercial matters subject to certain exclusions, and I'm going to come back and talk about those exclusions. If, however, the regime you're looking at is the Rome Convention, that was incorporated into English law by the Contracts Applicable Law Act 1990, and it was incorporated subject to certain derogations. The Rome Convention applies to all contracts entered into after the 1st of April 1991 and before the 17th of December 2009. Again, it applies to all civil and commercial matters subject to exclusions. It's also worth noting that various member states have incorporated the Rome Convention into their national law, but again, in certain member states have different derogations. And the final regime that may be relevant when determining governing law is the common law or statute or other international instruments. And so you need to check the relevant provisions as necessary. But as I mentioned earlier, today I'm going to focus on Rome 1. So just a couple of points on the application of Rome 1 before we look at some of the substantive rules. As an EU regulation, Rome 1 is directly applicable and no derogations are permitted. So unlike the Rome Convention, Rome 1 is incorporated in full into English law. It also has universal application, and by that I mean it will be applied by the English courts or other member state courts no matter where the parties to a particular contract happen to be domiciled. So that means that if the parties are from, let's say, India and Japan, but they happen to be before a member state court, the member state court will apply the rules in Rome 1 to determine the governing law that is to resolve that contractual dispute. The other point to note on application is that the application of the rules doesn't necessarily have to lead to a member state law being applied to a particular obligation. So, for example, the English court or other member state court will apply the rules in Rome 1 to determine the governing law of a contract between, let's say, Japanese and English parties, And the rules in Rome I may lead the English courts to determine that, for example, New York law or Indian law or Japanese law applies to that contract. It doesn't need to apply a member state law. So all of this is very similar to the position under the Rome Convention, but it is worth noting. And just by way of background, initially the UK had opted out of the draft Rome I regulation, but did participate in negotiations in relation to Rome I. And in June 2008, the UK opted into Rome I. So some further comments on application. The applicable law will govern the interpretation of a contract, the performance of the contract, and then Article 12 mentions that it will govern within the limits of the powers conferred on the court by its procedural law the consequences of a total or partial breach, including the assessment of damages, insofar as it is governed by the rules of law. So just pausing there for a moment, this is quite interesting and potentially novel in that it suggests, Rome I suggests, that the assessment of damages may be governed by the applicable law of the contract and not, for example, the procedural law of the forum. Further points to note, the applicable law will govern the various ways of extinguishing obligations and the limitation of actions and also the consequences of nullity of a contract. There are some differences to the Rome Convention under Article 12. Turning now to exclusions from Rome I. As I said earlier, Rome I applies to civil and commercial matters, but it does not apply, and these are the exclusions, to revenue, customs or administrative matters. And Article 1.2 provides certain further excluded areas, including, importantly, questions relating to the status or legal capacity of natural persons. And then it goes on to say, without prejudice to Article 13. Now, Article 13 of Rome I deals with questions of incapacity, so that's quite a complex area as to the scope of that exclusion. Secondly, it excludes obligations arising out of family arrangements. Thirdly, obligations arising out of matrimonial property regimes and wills and succession. Fourthly, it excludes obligations arising under bills of exchange, cheques and promissory notes and other negotiable instruments. And then I'm going to quote from the wording of the regulation, to the extent that the obligations under such negotiable instruments arise out of their negotiable character. Now, this is quite a technical definition, and negotiable instruments can broadly be described as instruments which can give the transferee a better title than that possessed by the transferor. And in this regard, I would refer you to Philip Wood's book on the conflict of laws in international finance. But the exclusion should not extend, it seems, to the contract pursuant to which an instrument was issued, for example, a subscription agreement for a bond issue, nor to the contract for the sale and purchase of the instrument. Whether a document is characterised as a negotiable instrument remains a matter of law of the forum. And so this is important, as a transferable security may be treated as a contractual obligation in one jurisdiction, but as a proprietary right in another. And so this means that a negotiable instrument, it may be a negotiable instrument in one jurisdiction, but not in another. So this is an area of complexity. Continuing with the exclusions from the Rome I regime, a further exclusion is in relation to arbitration agreements and agreements on choice of law, questions governing the law of companies, questions whether an agent is able to bind a principal or an organ to bind a company in relation to a third party, questions concerning the constitution of trusts and the relationship between settlors, trustees and beneficiaries, obligations arising out of pre-contractual dealings. These are dealt with by another European regulation on governing law of non-contractual obligations, that's known as Rome 2, and finally certain life assurance contracts. It's also worth noting that Article 1.3 provides that Rome 1 shall not apply to evidence and procedure. The Rome Convention had very similar exclusions. So turning now to the key rules in Rome 1, and I'm going to first set out an overview of those rules and then turn in more detail to discuss certain particular rules at Article 3 and 4, and then go on and talk about certain rules which may displace the general position. I'm now going to focus on the key rules in Rome 1 and provide an overview of those rules. I've set out on this slide an overview of those key provisions, and I'm going to look in a little bit of more detail at the rules in bold, focusing in particular on two principal rules at Article 3 and 4, and the rules that lead to the governing law which would otherwise be applied being at least partially displaced, because I think that they're important. They are also the rules which are always relevant no matter what the subject matter of the contract is, and so it's important to be aware of them. There are other rules that apply to particular types of contractual relationship, for example consumer contracts, that's at Article 6, employment contracts, and if you're looking at an agreement that falls within any of these specialist categories, then it's important to know these rules exist. For example, insurance contracts, you need to look in particular at Article 7. So, turning in more detail to the key rules in Rome 1. The rules which may lead to the governing law being partially displaced, at least, are set out at Article 3.3, Article 3.4, Article 9, Article 12.2 and Article 21. And there are also, as I mentioned a moment ago, some specialist rules that if you are looking at a particular type of contract, you will need to refer to, because they may include some displacement provisions. Now, the starting point for Rome 1 is, happily, that parties are able to choose the governing law of their contract, and Rome 1 is premised on the basis that parties have autonomy to choose their governing law. So for commercial parties, happily at Article 3.1, it provides a contract shall be governed by the law chosen by the parties. Now, a few points about that choice. The choice shall be made expressly or clearly demonstrated by the terms of the contract or the circumstances of the case. Now, most commercial contracts will include in the contract itself, in the written contract, a governing law. Where it is less clear is where you might have incorporation by reference, or parties may be contracting on standard terms. But where you have a standard contract that's signed by both parties, there's generally an express choice that has been agreed by the parties. And that is usually fairly straightforward. You can choose a governing law to govern only part of that contract, but that is not always recommended and can give rise to complexities as to which bit of the contract is governed by which law and which bit is governed by another, and how the two relate. The Rome Convention used slightly different wording. It provides that the choice must be expressed or demonstrated with reasonable certainty. You can change the governing law subject to certain provisos regarding formalities, and you can incorporate by reference a non-state body of law or an international convention, but you cannot choose that law to govern your contract, and in this regard parties should refer to recital 13. There are also some displacement provisions, obviously, which we'll come on and talk about in more detail. Now, what is the applicable law in the absence of a choice? Now, this is different from the Rome Convention, which relies on the closest connection test. Article 4.1 of the Rome regulation, Rome 1, sets out 8 specific rules for different types of contract. For example, sale of goods, that's the law of the seller's habitual residence. For the provision of service, that's the law of the service provider's habitual residence. Article 4.2, that's where the contract is not covered by 4.1, it provides that, or covered by more than one rule, it provides that it's governed by the law of the country where the party required to effect its characteristic performance has habitual residence. Article 4.3 provides that where it is clear from all the circumstances in the case that a contract is manifestly more closely connected with one country with a country other than that indicated above at 4.1 and 2, the law of that country will apply. And Article 4.4 provides that where the law cannot be determined pursuant to 4.1 or 4.2, the contract is governed by the law of the country with which it is most closely connected. So there are a cascading set of rules that one has to go through to work out which is the applicable law in the absence of choice. But returning to the sort of central premise, for most commercial contracts, one would expect to see an express choice of law in the contractual documentation, and it's certainly to be recommended in the interests of certainty. So turning now to consider certain other provisions. Article 10.1 of Rome 1 sets out the governing law regarding the existence and material validity of the contract, and says that it is governed by the law that would govern if the contract was valid. Article 10.2 provides that to establish that a party did not consent, a party may rely on the law of his habitual residence if it appears from the circumstances that it would not be reasonable to determine effective conduct in accordance with 10.1, that's the rule set out above. Article 11.1 provides that formal validity is governed by the substantive law of the contract or the law of the country where the contract was concluded, but there are also some alternatives. These are complex rules, and I just want to flag up that it is necessary to consider them if you are considering questions of consent, material validity, and indeed formal validity. Next, consumer contracts. Article 6 sets out the rules relating to consumer contracts, and I summarised a very simplified version of those rules on this slide. The general rule under Article 6 is that the law of the consumer's habitual residence will apply. However, the parties to a consumer contract can in fact choose a law to govern their contract if they wish to, although that is subject to the important caveat that the choice must not deprive the consumer of the benefit of the mandatory consumer protection legislation of the consumer's habitual residence. That's an important protection for consumers, and it's also quite a topical provision in the light of the debate ongoing in Europe regarding a proposed European contract law, or CECL as it's now referred to. There are, however, certain types of agreement which do not fall within the scope of the general Article 6 rules, even if they are entered into with consumers, including many financial instruments. And so if you are dealing with a consumer contract, it's important to consider these rules to work out whether your contract falls within or outside of the scope of Article 6 and what the practical consequences of that are. The next rule I want to look at briefly, and indeed with some trepidation, is Article 14, which is the rule which deals with assignment and contractual subrogation. This rule is very relevant in the capital markets and securitisation arena, where transactions regularly involve the assignment of debts and such like. On the face of it, Article 14 is quite straightforward. Article 14.1 deals with the relationship between an assignor and assignee and provides, as you might expect, that their relationship is governed by the law governing the contract of assignment. This is pretty uncontroversial and essentially reflects the position under the Rome Convention. Article 14.2 is also on its face relatively straightforward.